Hey, folks. Happy Thursday. It is March 7th, 4 o'clock p.m., 2024, and I am coming to you from the, uh, the Hall of Masks. You can see one of the masks up there. And it's super exciting, except that I'm getting a weird um, a weird reverberating sound, which I need to get rid of. There. All right. We are here. We are live. I'm in the hovering mask room. You can see the scary mask on the wall. Roger is in the sconce studio.
Yep.
Indeed, although you can't see the sconces. Anna is in the
Well,
World Book
bring them up.
Encyclopedia room of the palatial mansion. And oh, now the sconces are on. You still can't see them, but you know, but you can sense their presence. And we are here to talk about a week of Arcana. Arcana from Judge Eileen Cannon. Arcana, the jumping into a giant pit of the Fulton County case, the Supreme Court, and so let's just get into it. Um, let's start down in Mar-a-Lago because we haven't started there in a while. The week began, which is to say, last week ended with two morning and an afternoon hearing, and then there's been a lot of briefing. Anna, give us the and I'm just going to do a little spoiler. The end result of this is that absolutely nothing has happened because Judge Eileen Cannon doesn't believe in ruling on things. This was one of the questions that the Senate didn't ask her during her confirmation hearing. They didn't ask, do you actually believe a judge should ever issue rulings? And had they done that, you got to know what's the right question to ask, because they were thinking about ideology and they were thinking about all kinds of things. Were you a member of the FedSoc, whatever? But they didn't just ask her a question that she could have answered. It's like, do you believe judges should ever rule on anything? She would have given the honest answer, no. They would have thought, well, maybe we shouldn't have a judge on the bench who doesn't believe in ruling on anything. Anna Bauer, 5 hours of hearings in front of her or something. What we talk about? What happened?
Well, we talked about three things. The first, and maybe the thing that most people were focused on that day, is that Judge Cannon wanted to hear argument on these proposed trial schedules, pretrial motion practice, and then also, setting another trial date. Because although the trial was supposed to go in May, for a variety of reasons, in the fall things got really behind, and so Judge Cannon in November said that she would set a new trial date at the March 1st conference. So the March 1st conference rolls around. Both Trump and the special counsel's office submitted these competing calendar proposals. The special counsel's office wanted a trial set for July. Trump's team said, well, we really don't think that this should go to trial before the election, but if you make us tell you a date, we're going to give you August. So we had a lot of argument and back and forth on that. The second issue had to do with this question of whether Judge Cannon should allow Trump's team and the other defendants to have an evidentiary hearing on the scope of the prosecution team. This kind of came up in this motion to compel that Trump and the other defendants filed,
Anna, is there
where
something you're not telling me, that you are actually a member of the prosecution team?
Well, Ben, I actually think I'm one of the few people, because I do not work for a federal agency, who actually might be excluded from the scope of the prosecution team. But their definition of what the prosecution team goes well beyond, just the agents and the DOJ and special counsel's office prosecutors who have worked on the case. It basically would go to anyone who worked in a federal agency that just happened to communicate with the special counsel's office or DOJ in the course of this investigation. And so Judge Cannon, heard argument on this issue of whether she should have an evidentiary hearing on the matter, meaning that witnesses would be called. There would be things that would be, exhibits that would be filed with the court to be submitted into evidence so that she can determine who is in and who is outside of what the prosecution team is. And the reason that they want her to expand the scope of who counts as a member of the prosecution team is because they want to get more communications that DOJ had with some of these folks, people who are a part of NARA or, various other intelligence
Because they
agencies.
want the email where Joe Biden sent to Nara the note that said, plant that stuff on at Mar-a-Lago and then call the FBI and get them involved. And the CIA paused from the Taylor Swift PSYOP operation to, bully the FBI into investigating, right? And all that stuff is in internal communications that they want, right?
Yeah, I mean, that's basically the idea. Or if it's not that email, it'll be some other thing that someone has said somewhere that they could maybe that maybe is somewhat ambiguous, that out of context could look bad. And so I think that's the idea, is that they want to be able to get those communications so that it could maybe then later on support their motion to dismiss the indictment based on selective prosecution, or at least just flip the public narrative around the case.
Yeah, and is your thought that the goal here is really to get, to do a big dig, as they would say in Boston, and get the material and file a motion, or is the goal simply to slow everything down with evidentiary hearing after evidentiary hearing, and maybe if you get lucky, you get a kind of Fonnie Willis kind of situation where you can really change the subject and, put the deep state on trial. But if all you do is cause a few days of, of her rumination and maybe get an evidentiary hearing, you've eaten up some time.
Yeah, I certainly think that it's a bit of both. And already, the eating up a bit of time is already working. It's been a week since that hearing, as of tomorrow, and Judge Cannon hasn't even ruled. And this isn't even about the substantive motion to compel. This is about whether they even get an evidentiary hearing on the motion to compel. So, I mean, and it's taken her a week to rule since argument on that. And then, Ben, the final issue that we discussed is this issue that Roger's written a lot about. There's this kind of secret docket that's been created related to these ongoing redaction and unsealing issues that are going on within the case. Trump's team has pushed for a lot of things to be, unsealed or unredacted that they filed with, for example, their motion to compel. They had like a bunch of exhibits that included things like grand jury testimony and, the names of potential witnesses in the case. They wanted those things to be put on the public docket. Special counsel's office opposed that. Judge Cannon ultimately said that the special counsel's office didn't meet their burden of showing that, those things should be sealed or kept redacted. So then the special counsel's office, after that order, asked her to reconsider and said she applied the wrong standard. She applied a, heightened standard, First Amendment standard of scrutiny, whereas they said, they needed a lower, just a good cause standard. And so there was this, afternoon session in which the Media Coalition intervened and had someone come and argue their case, because the Media Coalition coalition wants those exhibits to be unsealed. Trump's team has said that the special counsel's office didn't meet their burden, and so those things should be unsealed. And then, of course, the special counsel's office is making the argument that things like potential witness names should be kept from public view for now.
And Roger, in the subsequent briefing, you mentioned that there had been a flurry of document activity or docket activity since that hearing. What's been going on the in the case since Friday?
Well, we just got a few motions about 10 minutes ago, which I haven't read. Some have to do with the Presidential Records Act. We got a couple Trump-aligned amicus briefs were filed addressing the Presidential Records Act. The theory that the amicus advanced was that basically Trump has unfettered discretion to say this is anything I say is a presidential record. It is, and so the government is now responding not just to the original motion, but it's going to have to respond to the amicus brief. There's another amicus brief from Steve Calabrese and Ed Meese and Citizens United that is once again arguing that the special counsel has is unconstitutional per se.
Look, if you make that argument in enough different courts, eventually you get a Judge Cannon who will take it seriously.
But so the government will have to respond to that one seriously as well. There's a tremendous amount of paper, but there's also been, there was a jury questionnaire was submitted, a joint, the government had hoped to submit that under seal, but she announced these new procedures where you need to, if you want to submit something under seal, you have to ask permission in advance, and you have to show with particularity in a public setting, in a public motion, why it needs to be sealed, and then you have the ordinary delay of you need to meet and confer with the defense counsel, and defense counsel doesn't make it easy to meet and confer with them. They have successfully had other motions stricken because the government did not provide enough time to meet and confer. So when you add all these requirements together, they couldn't do it in time for the deadline, and they filed it publicly. So anyway, and in that there happened to be the first estimates of how long this trial will take that I've seen. And the estimate, Jack Smith's estimate was 4 to 6 weeks, which is about the same as the DC case, at least the case in chief. And Trump was saying 8 to 10 weeks.
8 to 10 weeks for his defense or for the entire case?
No, for the whole trial. This is in terms of what you tell the jury.
Right.
The venire, the jury pool. But mainly, we're just waiting to find out what is the schedule, and also when might the first hearings be, or when will she decide? Trump asked for hearings next week, the 12th, the 13th, and the 14th. NADA is on a different schedule. It's very strange. His co-defendant wants hearings March 20th and 21st. The USA, the government wants hearings April 3rd, if any. So there's a lot of decisions to be made, and so we're just. And
she doesn't like making decisions. Anna.
Yeah. There's it already, I think, I would have to go back and look at the schedule, but I think that she's already getting really close to when some of these proposed dates were supposed to be happening. And, it seems like she really needs to make a decision here soon, but that has not happened yet. But something else that was interesting on the docket as well that Roger didn't mention is that today there was another response to the standing discovery order. That's where the government, every so often will update the court on, the state of what they've produced to the defendants. And so one of the, responses that the government made today indicated that they had an interview with someone yesterday that they then, handed over what they called a memorialization of that interview. So that was a little bit interesting. It's not totally unusual for prosecutors to continue to interview witnesses or re-interview witnesses or other, people as the case goes on, but it was, interesting to see that it was as of yesterday that they interviewed someone. So Roger and Ben, I don't know if you have any thoughts on that, but that was just a little kind of interesting thing on the docket.
I did see that, and there was also an interview in February with that caused one of, but I can't make anything of that one where, like you say, it could be I just don't know what to make of that.
All right. So do either of you have, I've been making fun of her about her slowness and indecisiveness, but do either of you have any sense of when we should expect, certain basic decisions like a trial date, when we're going to do the SEPA Section 5 stuff? We've got these pending motions to dismiss. We've got the motion for the motion to compel and the motion for to reconsider on that. Anybody have any sense of when this stuff is coming?
No idea. Unfortunately, she didn't mention at the hearing. She didn't say. She just said, "I'll take it under advisement." So no indication when she will rule. I will say she was asking, each side, what are your 30-day priorities? It may even be that she maybe doesn't set a trial date and just kind of sets a more short-term schedule potentially. But I do think she does plan to set a trial date. I just don't know when. The issue with the redaction seems to be something that was on her mind at the hearing. She had a back and forth at one point with Jay Bratt because her view on it was that if we don't resolve this issue of, things getting caught up in this secret docket where we don't put them out publicly because they're pending, whether they're going to be redacted or sealed or whatever, that's slowing down the motion practice. So I suspect that she really kind of wants to get this redaction and sealing issue kind of settled before the rest of the pretrial practice kind of continues. So, but again, I don't know when she will decide on that.
Roger?
Yeah, I don't know. I think that sounds right. There's a bottleneck right now because nobody knows what they can file and what they can't. And I think there are fewer and fewer reasons for the government not to consider appealing, a mandamus actions. I really think the prospect of winning this case in front of her are really, really difficult. And, she'll be making the decisions about the jury pool. And of course, you can't, if there's an acquittal, you can't appeal. So I think the two weirdest things are the thing about exposing the names of witnesses and FBI agents, if she's really going to do that. I also think the hearing in what is in essence the theory is a prosecutorial, vindictive prosecution, selective prosecution. There's never been such a hearing since the Supreme Court announced high standards in around 1995. If she's going to order one of those, I think that's a potential mandamus issue. And I think there's just no downside. I don't think you want to go to trial. Yeah, I mean, you already have a Florida jury, which is going to be difficult. If she's the one making the decisions about who to strike and who not to strike, that's going to be extremely difficult. She's making, I just think things are mounting up.
All right. On that cheerful note, let's bop 500 miles northeast to Atlanta and talk about the black hole that has eaten up the Fulton County Courthouse. A week ago, the place was humming. We were having oral arguments. We were talking about whether Fani Willis was going to emerge triumphant with a kind of "you go girl" thing, or whether she was going to be, humiliated and removed from the case. And then Friday, 5 o'clock comes along, and this big cloud of obscurity descends over Fulton County, and absolutely nothing has happened since. Anna, what's going on in Fulton County, Georgia?
Well, it's not that nothing has happened since. We have seen some post-hearing filings. So after that those closing arguments that we heard on Friday, which Ben, you listened into while I was in Mar-a-Lago, which was a funny change of pace with our usual roles, but since then, we've had a few proposed testimony filings. So we saw that there's one woman, her name is Cindy Yeager, who is a prosecutor in Cobb County, Georgia. Of course, Terrence Bradley, for folks who recall, who is the witness that was the former divorce attorney and former law partner of Nathan Wade, who was supposed to be the so-called star witness of the defense team. He was allegedly going to testify to Fani Willis and Nathan Wade being in a relationship prior to when they said they were in a relationship. But then it kind of, ended up being where he invoked privilege. And then when he did get on the stand, he said, no, I was just speculating. So if folks remember that background, Terrence Bradley practices in Cobb County. He's friends with this woman, Cindy Yeager. And she basically spoke to defense counsel and told them, I saw Terrence Bradley's testimony and it concerned me because I had conversations with him back in the fall. He was telling me all the same things about how, Fani and Nathan were in a relationship since 2019 and, et cetera, kind of repeating a lot of the claims that he told Ashley Merchant. And so they proposed that testimony from Cindy Yeager if Judge McAfee was to reopen the evidence. They also proposed similar testimony from Manny Aurora, who was defense counsel for Kenneth Chesbro before Chesbro pleaded out. And Manny, in the course of preparing defense for Ken Chesbro, also had conversations with Terrence Bradley, in which Terrence Bradley repeated a lot of the claims that he'd made to Ashley Merchant in the text messages and conversations they had prior to her filing her motion. And I think the idea that the defense had with these witnesses is that, by showing that Terrence Bradley had been talking to multiple people about these claims, they think it kind of shows that his testimony or not testimony, whatever it was he was saying prior to him being under oath is what was the truth. That is kind of what the idea was. But to my mind, I don't think that it really helps the defense that much because it still doesn't go to how Bradley knew any of this.
Yeah, and
What
also,
the
I mean, we knew the day he testified that there were some text messages that were in tension with what he was saying on the stand. We knew that the first time he testified. We knew that the second time he testified. What we didn't know is he telling the truth on the stand? Was he telling the truth in the text messages, or neither? Because
yeah,
the guy's a
exactly.
slippery
He's been
fish.
so inconsistent and so dishonest that you can't tell at any given point in any of this when it was that he was telling the truth. So
Right. And
and
so
and
the fact that he told multiple people
mm-hmm.
the same story that may or may not be true, as he told Ashley Merchant in those text messages, doesn't seem probative of whether the story was true then. It seems like it's roughly equally possible that he was bullshitting then and now is under oath and, could have his life wrecked. And so he's sobered up a little bit and is telling the truth, or that he was, you could say, maliciously going after Nathan Wade then and is under oath now. Or you could say, well, he was telling the truth then and now he doesn't want to do it in public, so he's lying now. But I'm not sure the fact that he told three people the same story makes it any more likely to be true.
Right. I think that, and that's exactly my point, is that I don't think that testimony helps the defense maybe as much as they think that it does. And I also just don't think, I think it's cumulative of, other things that Terrence Bradley said in those text messages. So I'm pretty doubtful that Judge McAfee will reopen the evidence and allow that testimony. I also just will briefly mention, because I'm not sure if I mentioned it last week, but the prosecution also proffered some additional testimony if evidence is reopened. They wanted this winery employee to testify that Fonnie Willis paid in cash when she visited the winery with Nathan Wade back in, spring of 2023, I believe it was. The idea being that helps corroborate Fonnie Willis's claims that she has a tendency to pay in cash. And also that, she was paying for the wine for both herself and Nathan Wade, meaning that their, story about having, or excuse me, testimony about having kind of in kind, one person would pay one thing one day and then the other person would pay something else later, and it all kind of equaled out, that there is some corroboration to that as well. So we have these additional proffered testimony. Then we also had some closing arguments in brief form from both the prosecution and the defense. It's basically kind of just a written version of the closings that they had on Friday in Fulton County, which we discussed on our live stream last week after the hearings. But basically, the prosecution says that there's no actual conflict. The defense didn't meet their burden of proof here. You have to have an actual conflict of interest to be disqualified as an elected district attorney, and that just hasn't been shown here. And then the defense, there's been a few motions that are still rolling in. We had one from Jeffrey Clark, one from Trump's team, both addressing different things, but Trump's team basically said that that Fonnie Willis should be disqualified on grounds of forensic misconduct, not necessarily an actual conflict of interest. And that is based on, a totality of circumstances, including her speech that she made at the church, in which she, implied that that these allegations were motivated by racist attacks. And then also that she allegedly, was untruthful under oath. So We had a few of these post-hearing briefs. I think there might still be some defendants who might file them, but Judge McAfee said he'd decide within 2 weeks. I think that's very likely to be next week, not this week, because tomorrow is the qualifying deadline for judicial races. Judge McAfee's already qualified for his race, and there's somebody who, as reported by the Atlanta Journal-Constitution, is planning to challenge him. So I think that it's unlikely that we'll see any sort of movement in terms of this decision until it's sorted out who, if he actually does have someone who is opposing him for his judicial seat.
If I could just add a couple things, and I totally agree with Anna about those two proffers by the defendants that talk about Bradley, and it just doesn't add a lot. But there was one thing in the Yeager affidavit that gave me pause, and maybe Anna has more perspective on it, but well, there were sort of two things. Yeager, they described her as a fairly high up prosecutor in Cobb County. And then they said that she was talking to Bradley, and Bradley got a call from Fani Willis. And after, the merchant motion had been filed, and sometime after, and she said she was telling, she overheard Fani Willis telling Bradley words to the effect that they're coming after us, you don't need to be talking to anybody about us. And that was like one more drip. It's not, the picture I'm getting is really not a great picture. I'll just say one other thing, and then the other thing is that the state, as you said, filed its brief, and I just wanted to mention, because last week I had heard Abate do this oral argument, Abate being the state's representative, trying to argue before McAfee about the law, and he had not given a great, I didn't find his presentation very, I thought it was confusing. The written work was much more convincing about that there is a higher standard here, at least for disqualifying an elected county attorney. I thought he made a good point that it's a higher standard than I realized. But
yeah, and I think it's actually, I think they got that argument that they ended up making about there being, looking at the district attorney being a constitutional officer. I think they got that from Anthony Krice. He wrote an article in the AJC about that topic, and someone's linked it there in the chat. So if anyone is interested in maybe where they got that argument from, although there is, even not putting aside that argument that they made about kind of needing an actual conflict because of the nature of a district attorney being a constitutional officer under Georgia's constitution, there is so much appellate case law that suggests that there is a higher standard for disqualification of district attorneys as opposed to, for example, a judge, where the appearance of impropriety would be sufficient. But Roger, to your point about the call, I need to go back and look at the filing, but I'm fairly certain that phone call did not, it maybe was written in a weird way in the filing, but I think that phone call took place in September of 2023. So it was well before. Yeah, and the reason that she, as I understand it, and as I read it, the reason that the phone call was made to Terrence Bradley is because there was a, article that was written at the time that was about how much money Nathan Wade was being paid for the prosecution. This was, when Manny Aurora and Ashley Merchant maybe started talking to Terrence Bradley, but it wasn't at a time when he knew he was going to be a witness. Anyone thought he would be a witness in the case. And so I've seen a lot of kind of right-wing outlets who are saying, oh, this is witness tampering. But I actually think if you look at it in context of it's someone, and everyone has to keep in mind, this is a small legal community. These folks have known each other for a long time. It's a response to something in the media and talking about, that, as opposed to they're coming after us, meaning the defendants, and that this is, thinking about Terrence Bradley potentially being a witness in the case. Does that make sense?
Yeah, absolutely.
Yeah.
All right. So, bottom line, like South Florida, we have a bunch of pending motions that are just kind of piled up on Boy Wonder's desk. He's been much more expeditious than Judge Cannon in resolving things, but he's got a bit of a backlog at this point too. And the substance of that backlog is basically, whether she gets to continue on this case or not. Stunned silence. All right, let's go another 500 miles north to the Supreme Court, which this week ruled 9-0, and by 9-0 I mean 5-4, that Trump is going to appear on the ballot in Colorado and everywhere else. And Roger, I think people have heard a lot about this subject already, so I don't want to dwell too much on it, but I do want to focus a little bit on the question of why the liberals and Amy Coney Barrett were so upset, them a little bit more vocally than she, and what really turns, on this distinction that that they are making from the majority opinion, which, they are accusing the majority of doing more than it needed to do. What turns on the distinction between what they would have done and what the plurality or the majority, in fact, did?
Well, what the 9 really agreed on was the point, obviously, that the states can't enforce Section 3 against federal officers. They can enforce it against state officers, and they can do that even without congressional legislation. So it's apparently self-executing with respect to state officials. With respect to federal officials, what they did by going further was, it seems, and there are plenty of obscurities, but they have basically excised Section 3 with respect to federal officials. If the majority thinks Section 3 doesn't exist unless Congress enacts something to enforce it. That's how I read it. The only conceivable thing at the moment would be a prosecution for insurrection under 18 U.S.C. 2383. So that flips what the apparent, you read Section 3 and you think the default setting is as soon as you commit insurrection, you're disqualified from all these, if you're an oath-taking insurrectionist, you've taken an oath to one of these offices that's listed, then you are disqualified, boom, immediate. And then Congress can, in its, mercy, lift the disability by 2/3 of each chamber voting to do so. They've sort of flipped that. The default setting for federal officers right now is you're home free. It's okay. You can have any office, federal office you want, unless Congress votes by a majority, the House votes by a majority, the Senate, you'll need 60% probably because of the filibuster rule, and then the president has to sign it into law. You need legislation to get this thing started, and only then does would Congress maybe consider lifting the disability it has finally imposed. So it really zaps the whole thing with respect to federal officials. I think that's what they were so upset about. And by they, I really mean 3 of the 4, Sotomayor, Kagan, and Jackson. And there was some extraordinary language. The extraordinary language was they decide novel constitutional questions to insulate this court and petitioner from future controversies. They're saying they are, reaching out and protecting Trump. That is really something, and that's what Justice Barrett was not willing to join.
But here's what I don't entirely understand about the liberal justices' objections here. If they had had their way, and the holding had simply been a state cannot keep Donald Trump off the ballot without some kind of congressional permission, it would have amounted to, I think, the same thing, because Colorado gets swatted back. And in practice, how does it operate any differently?
Well, here's what I think. If Trump becomes president, there are a lot of, suppose he issues an executive order and somebody challenges that executive order and says, just like, it's like Griffin's, I don't know if he challenges the order and says it's invalid because the president is disqualified. Then you would have been able to litigate before a federal judge whether he's disqualified. And I think what they would want is they want people to know that it's still hanging over his head, that this hasn't been, yeah, you can vote for him, but he did what he did.
And this issue and how it processes under Section 3 hasn't been resolved.
Exactly. And they gave an example, which was a weird one, about what about if an insurrectionist prosecutes somebody? I mean, there's a lot of people besides Trump. Well, there aren't a lot, but there are some that could be working their way up. There was a fellow, there was a state legislator in West Virginia who was charged with felonies on January 6th. He resigned at that point. I think he's back in politics. He might eventually want to run for the U.S. Congress. These people seem to be home free. There might be other ways. And of course, the big question is what happens on January 6th. Is there a way to, and I would not be thrilled if this happened, but people did wonder, could you object to slates based on the idea that he's disqualified? And I think the majority was trying to even eliminate that, and I think the concurrers are all saying you reached out to protect him, and you just annihilated a section of the Constitution that isn't really what we usually do.
or at least, if not annihilated, annihilated in the absence of congressional action that we can anticipate will not happen.
Yeah.
All right, let's go 3 blocks south of the Supreme Court. We're doing this in a very organized geographic fashion, to Judge Tanya Chutkin's courtroom in the E. Barrett Prettyman Courthouse, which is a horrendously ugly building, unlike the Supreme Court, although the annex to it is a lovely building. And it is, I think, one of the buildings in Washington that has kind of the nicest modern section relative to the ugliest kind of brutalist section. But that's neither here nor there. Anna, what's going on in Judge Chutkin's courtroom?
Well, Ben, there's not a whole lot because the cases still stayed. But so there's basically nothing going on in Judge Chutkin's courtroom because the case is on pause while the Supreme Court takes up the issue of presidential immunity. But we did get this week a date for the presidential immunity oral arguments.
Yeah, we have a briefing schedule.
We do, and we have a date for oral arguments, which is April 25th, which is the last day of the court's term. So they really are
They're siding more with Judge Cannon on the speed of doing things than with me or you or Roger.
Right. So that's all that's happening, basically.
All right, all of which brings us to the case that is actually happening. And it's happening no fewer than 18 days from now, which is in Judge Merchan's courtroom in New York, 236 miles from the E. Barrett Prettyman Courthouse. Just rough estimate. Somebody with Google Maps can tell me how well I did on that guess. It's looks like we have a trial that's going to happen on the Stormy Daniels stuff. So I want to throw this open to both of you. First of all, what is the wrench that who can throw into this trial schedule? Judge Merchan says we're going forward on the 25th. Donald Trump wants to have a temper tantrum and ask somebody to prevent it. Can't really ask the federal courts to prevent it because it's a state court proceeding. They've already denied removal. The judge doesn't seem sympathetic. So my first question is, are we going to have a trial starting on the 25th?
I mean, I think that I can speak to this because this came up in Judge Cannon's courtroom on Friday. She asked Todd Blanche, who is also representing Trump in the New York case, is this a firm date? What's happening? Are you asking for a continuance? And Todd Blanche, of course, said, well, we're going to ask Judge Merchan for a continuance every time we are in front of him. And that was a literal
quote.
He's
at least being pretty straightforward about it.
Yeah, but he said, Judge Cannon, he's denied us so far every time that we've asked for a continuance. So I think that this trial is actually going to go. I guess that there could be something that delays it during jury selection if jury selection takes longer than expected, or there's some kind of, who knows? Weird things can happen, but I think that we're going to trial with this case at the end of the month.
What do you think, Roger?
I assume we're going
Do
to
I
trial.
do I need to get an Airbnb in New York?
We might. And also, I think this is a pretty tough judge. I think he's not easily derailed.
All right, so March 25th, jury selection begins. I want to take a poll. How long do you think it takes to seat a jury to judge Donald Trump in a criminal case in Lower Manhattan? Is that a 3-day thing, a 3-week thing? a month. It's not Fulton County, so we won't say it's a year. But what do you think? How long is that going to take?
I'm guessing about 2 weeks for the jury selection. And then they've said, they've estimated, I think the people have estimated 5 weeks. I think that includes, he doesn't sit on Wednesdays.
Right.
I
He's
don't know
called
if
it a
that
day of rest,
Yeah,
which is,
so.
Wednesday.
uh, So I think that's the idea.
What do you think, Anna? 2 weeks minus Wednesdays?
Yeah, I mean, New York courts at this point have experience now with seating a jury for trials against Donald Trump because there's been a few, but I think yeah, 2 weeks sounds right. Todd Blanche, I believe he said that the estimate was 6 weeks for the trial total, and I think that might have included jury selection actually, but he was kind of saying to Judge Cannon, but Judge, you never know, things keep getting extended, and it just could go on, and because he didn't want Judge Cannon to set a July trial date. So I who knows, but I believe that the estimate from Todd Blanche in the hearing on Friday was that the total time would be about 6 weeks or longer.
Yeah, I mean, I gotta say, having looked at uh, reread the indictment and the statement of facts the other day, along with Judge Merchan's ruling on the motions to dismiss. I have to say, it doesn't feel like there's a whole lot of evidence to present in this case. You're going to hear obviously from Stormy Daniels and Karen McDougal. You're going to hear from some witnesses associated with the National Enquirer organization, the comically named David Pecker, and you're going to hear from people associated with the Trump organization, as little as possible from the prosecution's point of view, from Michael Cohen, I suppose, but you're going to have to hear from him on some things. But you're not talking about, it's not an especially complex fact pattern, I don't think.
I think that's right. They're trying to shave it down some on the Trump's people on motions in limine, trying to, but I doubt they'll succeed. But yeah, like you say, I think it's manageable. I think there were something like it was over 300 exhibits, but that too is not, you
Yeah,
know,
that's, if you have 10 witnesses, they show each one 30 pieces of paper. It's not a, all right. So we all think it's going to happen. I'm still trying to figure out, do I go out to California on April 1st for a conference? Is jury selection going to be done? You're saying maybe. I don't know. I don't know what to do about that. All right. We are going to go to audience questions. But before we do, I have a message to those of you who are joining us on YouTube. We're not going to be answering your questions today, and it's not because we don't love you. It's because this is a forum where we answer the questions of material supporters of Lawfare. You can become one. You can join the benighted few who are actually in our studio right now. And you can add your questions. You can read them yourself. You can have me read them. But to do that, you got to go to lawfaremedia.org/support. Now, for those of you who are just in it for the Trump trials coverage, we have another option, and that we've just made available. We're going all NPR on you guys, and we're asking you, and there's a link that is in the YouTube thing, in the chat, pinned to the top. It is just to support the Anna, Roger, Ben, Tyler, our New York bureau, the people who are doing the Trump trials. This is a big lift for us, and we're gonna be there. We've been there at every hearing, front of the line kind of stuff. And we're actually heading to trial in New York, and it's going to be a big lift. We're going to be there every day. We're going to be doing daily debriefs on this format and in podcasts, and we need your support for that. So go to that link if you want to become a material supporter, a regular kind of monthly supporter. Go to the Patreon. If you want to just support the trial coverage, go to that link pinned at the top. Come into the light. There's 515 of you watching right now. There'll be 10,000 people who will watch this before we do it again next week. You know, if 20% of you give a donation to Lawfare, we will we will be in a much better place than we are right now, and I can harangue you further about this next week. All right, we are going without further harangue to audience questions. My Lord, there are 820 of them. So we're going to go fast. Supergiant Robot asks, what impact does the ICAP settlement in Michigan have on the January 6th case before Judge Chutkan? Are the 1,400 pages of email and text messages new evidence for Jack Smith's trial team to work with? Short answer to that question, in my opinion, and I will say that Mary McCord, who's the head of ICAP and ran that litigation, is a friend and somebody I think very highly of. Look, there's a lot of new material in there, and a lot of it shows that Ken Chesborough was not the only actor among the lawyers to be central to this. There was this other guy whose name is escaping me right now, who was pretty Trupis, right? Whose actions were pretty central too. Now, was Jack Smith aware of that? I don't know. Probably. Did he have all these emails? I don't know. Maybe. If he didn't, I'm sure they will be reviewing this stuff.
I mean, I will say I would be surprised if he didn't have the emails. And I don't know about the text messages, but I will also just say that in Fulton County, for example, they executed search warrants related to Ken Chesborough's email accounts. So I think that they should have these emails as well. But I mean, I have no idea, but at least with respect to the emails, I don't think that those are going to be new to any of the Jan 6 investigations.
Yeah, I mean, one way to think about it is that the power of criminal investigators, particularly at the federal level, to get information is dramatically better than the power of civil litigants. And so, as a general matter, you should operate on the assumption that the Justice Department knows stuff that other people are only just finding out. That said, there are times when that assumption is not true. By most reporting, Cassidy Hutchinson's testimony came as a surprise to the Justice Department, and she was really found by the January 6th committee. So, it's a good rule of thumb, but it is a rebuttable presumption, and I think all we can really say at this point is that the civil litigants here did a very good job. They unloosed a lot of new information, and we will find out whether it's new to the Justice Department as well as to us. All right. Laura asks, if Judge McAfee refers Willis to the bar instead of disqualifying her, what's the worst case outcome? That's an easy question. The bar's power is limited to two things. One is they can discipline her as a bar licensing matter, up to and including disbarring her. And secondly, they can refer her to an office for potential criminal prosecution if they think she's committed crimes. Most referrals to the bar don't lead to anything of the kind in either department. They lead to something uh, negligible or much less severe, but those are sort of the limits of what the bar can do. Anne asks, I know this is a bit outdated, but it has been bothering me. In the New York civil judgment, the judge noted the proceeds each Trump family member received from the OPO sale and the amounts Don Jr. and Eric, about $4 million each, were roughly the same as they were ordered to disgorge. But Ivanka also received that 4 million or so, and she was dismissed from the case. So does she really get to keep her proceeds while her brother and dad have to pay theirs back? So I am not all that conversant in the details of the New York civil case. I will say, as a general matter, that life is unjust, and civil litigation does is a very rough tool toward restoring justice. Do either of you guys know why Ivanka has been able to keep her $4 million?
Well, I mean, I will just say as a general matter, and Roger, you are much more conversant in this case than I am, but she was, severed or she was removed from the case. So I would just assume that any judgment is against the people who are actually the defendants in the case and not her. And so therefore it would follow that, yeah, she does get to keep her proceeds. But again, Roger, you might have a better answer than I do.
Yeah, she gets to keep her proceeds. Um, what happened was she left Trump Organization before the others did, and there was a statute of limitations issue. And after she left, um, the, uh, the defendants involved here signed a tolling agreement so that the government could keep, I mean, the people could keep investigating. And so she's at this point barred by statute of limitations, and she lucked out.
So, Ivanka, if you want to donate any part of your ill-gotten $4 million from which you've been insulated by the court to Lawfare, you can go to lawfaremedia.org/support, and we will take off your hands as much of the $4 million as you feel it would require to expiate your conscience. All right, anonymous attendee asks, if the Supreme Court Section 3 rulings who I'm having trouble parsing this. It's because I read the wrong first word beginning with I with two letters. In the Supreme Court Section 3 rulings, who are the federal officers besides POTUS and the vice president, since there is a legal argument that representatives and senators are members of each house, not officers and elected only by citizens of their district or state, and can be disallowed from being seated by each house and do not owe their existence to the whole of the people. Is this one of the overreaches the ruling that the concurrences objected to, or is it an actual flaw in clarity? I am not sure I entirely understand that question, but Roger, I will dump it in your lap.
I think I understand it, and before this happened, I mean, a lot of people were, a lot of would-be congressmen and I think a senator or two were excluded under Section 3 by those chambers. And, you know, the Constitution always gives the chamber the power to exclude people that it doesn't consider disqualified at the beginning of the session at least. And I think they can do it. I don't want to get too far over my head here. I think they can do it by a majority vote at the beginning of the chamber. To expel somebody, they need to have a higher vote. But they've always had that power, and they've exercised it in these Section 3 matters. And I think the assumption is they could still do that. They might, they could just say, they could say, they might not need to call it Section 3. But I think the assumption is they can still do that.
All right. Catherine asks, will you open up a fourth section to the Trump trial's docket watch for the upcoming Bragg Stormy Daniels election interference trial? Please. The answer to that question is we have candidly focused on the other three because they implicate national security issues in a way that this one does not. And we weren't honestly sure we were going to cover it at all. Now it does seem like we are going to cover it, and we will probably open up a docket section for it sometime before it goes to trial. So a tentative yes on that. Mary asks, what exactly is it that the Supreme Court expects Congress to do? It sounds like they alone will be able to judge if what Congress does is acceptable or not. Am I way off base? Let me take a crack at that, Roger, and then, so Section 5 of the 14th Amendment is an explicit grant of power to give Congress, that gives Congress the authority to pass legislation to implement the other sections of the 14th Amendment. And what the Supreme Court is saying is that Congress has to create some procedure by which adjudications of disqualification happen. And it's done so in various ways in the past. For example, in the Insurrection Act, it says if you're convicted of this, you're disqualified. In the quo warranto statute that Congress passed in the 19th century, it like basically created a go to court and get a declaration that the person is out of office. There are a number of ways Congress can do it, and the Supreme Court doesn't really go into that, probably knowing that this Congress is not going to do it. But I don't think there's no assumption in the opinion, at least not as I read it, that the Supreme Court will fly spec the way Congress did it, just that it has to be Congress that does it.
I disagree just a little bit. There was a weird section, and I think this was really obscure, and I think it was part of many things that pissed off the concurrers. They said, so you have to use Section 5 to define, to enforce Section 3, and then they go on and they say, but remember, anything you enact, it has to be remedial. It's not a blank check, because we have, look at our City of Bourne versus Flores decision of 1997, and they struck down a statute where Congress had basically tried to overturn a Supreme Court decision in the religious freedom area, and they said, well, the statute was enacted under Section 3 of the 14th Amendment, Section 5 of the 14th Amendment, because it had to do with religious freedom. We're not talking about Section 3 here. And they struck it down on the theory that Section 5 doesn't let you go beyond remedial legislation. And why would they? They're already way out ahead of themselves. There is no legislation. Why would they be saying, you need it, plus you better watch out and not make it overbroad? I don't know what they were saying. and I don't know what the concurrers feared they were saying, but there was something there that was going on in the I forget what off stage, and I can't make it out.
Yeah, I think I remember those cases, City of Bernie and that line of 11th Amendment cases, and the frustration of the then different liberals than are on the court now, but the frustration of the dissenters in those cases was that the court didn't recognize that Section 5 contained any inherent authority to interpret the substance of the constitutional rights at issue. And so, I suppose if you inject that sensibility into this issue, you would say, all right, the court remains the arbiter of what is an insurrection and what it means to engage in it, and reserves the right to say, okay, Congress has, been too broad in its definition of that. But I don't think, I don't think the dissent in City of Bernie is really that the court shows no deference to Congress on the substance of what the 14th Amendment contains. And I think that's honestly less of a problem here, since I can't imagine Congress adopting a particularly overbroad definition of engage in insurrection. All right. Ron asks, now that Justice Barrett has admitted that the law is influenced by politics, what impact will dispensing of the fiction have on the panoply of cases? I think that's a little beyond the scope of our remit here, but I will just say that I don't think that's what she was saying. I think what she was saying is, hey, I agree with the libs that the court went too far here, and I don't appreciate their political rhetoric. And I think the big takeaway here should be that we all agree on the outcome. I do think the part of her concurrence that I found really weird and objectionable was that last line. I don't have it in front of me, but she said something like, that's the message Americans should take home from this, which I thought was just like applying her own spin to the opinion. It was like Amy Coney Barrett, manning her own spin room for the opinion. I thought was a little distasteful, but I actually agree with the substance of her opinion that the libs are right that the majority did more than they needed to, and B, that some of their rhetoric is a little bit overheated. Do either of you have thoughts on this?
Honestly, I was glad there was some rancor.
Roger, spoiling for a fight, Parloff.
Well, as it was, Trump came out and said, oh, it was 9-0. They all agreed that, Biden shouldn't be allowed to use this Civil War amendment to prevent me from taking office. A perfect 9-0 is going to lead to hoax. See, I won. And I'm glad to see some rancor. It was 5-4 on some issues, and in that sense.
All right, Nate, you have the next question.
Good morning, everyone from Melbourne, Australia. As Roger explained, the Supreme Court's decision.
Oh,
no,
we got you now.
Still inaudible? There we go.
Yep.
Thanks. Good morning, everyone from Melbourne, Australia. As Roger explained, the Supreme Court's decision in the Section 3 case was sort of fundamentally premised on this rejection of what they called the chaotic state-by-state patchwork that could result from states having authority to enforce Section 3. Of course, this wouldn't practically occur, but is there anything that would legally prevent a state from passing a state constitutional amendment in the exact same terms as Section 3 that would cover their state's electoral laws and work to prevent oath-breaking insurrectionists from being candidates for president? Could the US Supreme Court review that state constitutional amendment, or would they just be stuck with that chaotic state-by-state patchwork that they didn't want? Thanks very much.
So I have thoughts on this, but Anna, Roger, you guys go first.
I don't think they could do that. I don't think, we have a supremacy clause, and that applies to state constitutions as well. The state can't trump the federal constitution.
Anna?
I mean, my initial thought would be the same as Roger. So you go ahead, Ben.
Yeah, so it does not cure the constitutional problem that the court unanimously, and this is the part of the opinion that is unanimous, and unanimously identified to say that it's in a state constitution rather than in a state statute. To the extent that a state constitution sought to do that, it would be unconstitutional under the federal supremacy clause for the same reason that this has a problem. That said, I do think the questioner has picked up on what I think is the stupidest and weakest part of the opinion, and by the way, affects all 9 of them. That they all accept this idea that a crazy patchwork quilt of electoral law is unacceptable, and they all, like 9 of them, ignore that Colorado could tomorrow change its electoral law to say we're not having a presidential election at all. We're giving our electors to the candidate who dances best to the following 6 tunes, and we're going to assign our electors by an American Idol like dance competition, and 100% of our electors go to the one who wins that. And by the way, the Republican candidate will get 3 extra points because we don't purport to be fair in Colorado. If Colorado assigned its electors that way, and Mississippi assigned its electors by saying, the taller candidate gets the electors, the patchwork quilt would be way crazier. And nobody would question, at least not on this court, the fact that the electors clause of the Constitution affirmatively grants the states the authority to choose the manner of subject to a very small number of conditions that don't include election by popular vote. And so I think the premise of the whole opinion is not just wrong, but stupid. But that's just me. All right, Matt, we've got 10 more questions and we've got 13 more minutes. So I'm going to read fast and we're going to all be quick. Matt asks, if you assume as I do that there are at least 2 members of the Supreme Court who would like to delay Trump's January 6th trial as long as possible, can't we be pretty confident the decision on the immunity case will come out as late as reasonably possible, late June, early July? It won't be early July. The term ends on the last day of June. Can't they take as long as they want to write a dissent or concurrence, and won't the court wait for them to do so? Follow up, is there any chance an agreement to avoid this kind of delay could have been the subject of negotiation with the liberal justices who concurred in the Section 3 case? Roger, what do you think?
Well, I think I'm becoming almost as cynical as the questioner. I think that I honestly, I don't think they'll decide it on the last day of the term because it'll look bad. I think they'll decide it on June 4th so that, SCOTUS's apologists can say, oh, it's a compromise. It's not as long as it could have been. It's shorter than some, but they will ask for findings. They will ask, and they're deciding, probably they'll ask for Chutkan has to make some additional findings. And once she makes those findings, lo and behold, there will be another interlocutory appeal available. At this point, I don't think they're going to let this go forward for one day before the election. And I don't, I can't articulate a good reason for it. I think in in the minds of 5 justices, it has, in their mind, that's being non-political. To me, that is not being non-political. There is a indictment in place. Why are you getting in the way of it? You wouldn't get in the way of it with any other defendant. And don't we have, doesn't the electorate have a right to know whether one of the candidates is a criminal? And, but 5 of them think, oh, no, that would be, we would have the appearance of being political. So I don't think that's going to happen. In fact, unless Biden is elected somehow, I think this case will vanish.
All right. Follow-up question from Michael. I have some pessimistic predictions about the Supreme Court. 1, I think they will hand down the immunity decision in the last week of June. Roger's already said he disagrees with that. 2, it will be fractured plurality opinion that remands back to Chutkan for further fact-finding that could not possibly conclude in 2024. 3, SCOTUS will also narrowly interpret Section 1512C2 such that many January 6th offenders benefit. Do you care to talk me off the ledge? I think the coalition of Democratic forces will not be getting any more help from the court. Most people in power prefer not to stick their necks out, and the justices are no different. What do you think, Roger? Can you talk Michael off the ledge here?
I'm afraid
You're clearly somewhat on the same ledge as he is.
Yeah, no, I'm afraid I can't. I think he's probably right on both counts.
All right.
I'm sorry.
We already.
Anna, I think, wanted to say.
Oh, sorry, Anna.
Oh
Go
no,
ahead.
I'm on the ledge too. So
Oh, okay.
I'm not going to talk anyone off of it because I'm right there with you guys.
I am going to talk people off the ledge, but not in the way you think. This case was this election was never going to be decided in a federal court, and Bob Mueller wasn't going to save you, and Jim Comey, my old friend, will be the first to tell you that nobody should be investing in him to save you, and Jack Smith isn't going to save you, and Adam Schiff isn't going to save you, and none of the big tall men are going to save you, and the courts aren't going to save you either. If you don't want an autocracy, you have to actually act like democratic citizens, which all of you guys do. But the electorate has to decide that, and you can't slough that to the courts. Jared says, if Judge Cannon gets removed from the case, how much of her pretrial work will need to be redone? That's an interesting question, and I don't think I know the answer to it. Roger, do you? Anna, do you?
I mean, I think it's just like a normal reassignment where the judge who the case is reassigned to just continues on with the work. I mean, I suppose there are some things that would be discretionary, like trial schedule stuff that would be subject to change with a new judge, but I don't think that it's like you have to start over again and issue new rulings. I think
right. The question is, how many of her existing rulings would somebody move to reconsider on the basis that this was a crazy ruling issued by a person who's now been removed for bias?
Well, so far, I don't think that there are a
she
whole
hasn't done
lot
enough to-
that, yeah. So, I mean, it's hard
It's
to
one
tell.
of the advantages to not ruling on anything.
If there are these motions to dismiss, though, well, I guess that that raises a whole other question. But so,
Well,
yeah, go ahead.
Actually, if she grants a motion to dismiss, that would be great, because that's not an interlocutory appeal. And in order to grant a motion to dismiss, you'd have to have reasoning that's so crazy that the bias would then be self-evident in a fashion that would present very well. It'd be a one-day victory for Trump, but you'd actually be able to get it reassigned. All right, plowing on. 6 more questions, 6 more minutes from Devin Nunes's lawyer. Letitia James has been taunting the former guy, including on her official New York AG Twitter page, posting updates on the monies he owes the state and regularly adding the interest to show the higher amount, like around $470 million now. It makes me uneasy to see that kind of trolling from an AG. Like if a plaintiff's lawyer wins a big award, he might crow about it, but this feels almost like a Trumpy play and pretty unprofessional. What do you think, folks? I want to take this myself because I've had a bee in my bonnet about Letitia James's extrajudicial statements since she ran for office promising to go after Trump, which I thought was wildly inappropriate. And I think she has done, in many ways, an excellent job with this case, but I don't like her propensity to talk about, to troll, to promise outcomes. I think it's wrong when Donald Trump does it, and I think it's wrong when Letitia James does it, and I don't like it, and I very much agree with the premise of the question. Come at me with any disagreement, guys.
Pass.
All right, Josh says, when can Roberta Kaplan, speaking of people who are allowed to crow about getting money, when can Robbie Kaplan start seizing stuff to satisfy E. Jean Carroll's judgment? I think the answer is soon.
I think if there's no stay, it would be something like March 11th. Does that?
Yeah.
Yeah.
Kerry asks, there's a lot of speculation that Trump is trying to raise the money he needs to put up for the judgments. Are there restrictions on where that money can come from? Answer, yes. You can't use campaign money to satisfy personal judgments. You could raise money as long as you are honest about, like it's a legal defense fund design. I need $470 million. By the way, I need $470 million to run Lawfare, which is why you all need to click on that button so I can, keep these two fed and happy. But, you have to be as honest as that. And I think if Donald Trump put up the help me fund my judgments so that I don't have to sell my buildings, that might be a harder lift than raising campaign funds. Graham says, I've seen Justice Barrett's opinion interpreted two ways. One as criticizing the liberal justices for dismissive language, and the other as criticizing the conservative justices for going farther than they needed to in insisting that Congress had to pass enabling legislation. What is your take? Guys, I've already given my take on that. What do you guys think?
Well, it was a little odd because she's concurring because she does disagree with the majority, but she goes after the other concurrers. So it was a little odd, but yeah, she wanted the appearance of the 9-0.
Yeah, it's a bit of both. Anna, do you have thoughts?
I don't think anyone wants to know my thoughts about any of these opinions. They strike me as just such a low point for the court. I think they all really failed to even say what they meant and write an intelligible opinion. Yeah, I'm just gonna hold my peace on this opinion because.
All right.
Yeah.
Because someday you may have to practice in front of them. Lawrence asks, what should we make of the fact that the concurrence by the three liberals in the Supreme Court disqualification ruling was apparently originally a dissent?
Yeah, I've seen that. I've seen speculation about that. I really don't know. It's very hard for me to imagine. It seems like more like there might have been a typo, a mistake, because I can't imagine that one of them was going to say, yeah, let's uphold the Colorado, the disqualification in some respect and yet concur
It
in
must have
some
been a
oth-
concurrence in part and a dissent in part if those
That,
stories
oh,
are right.
no, that's what it says, but I still can't see, how would that work? What would you be I don't understand that split. And one other speculation out there, which is sort of possible, is that there was something in there that pissed off the concurrers, and at the last minute, they took it out. And there's that theory that maybe people are discussing something that no longer exists. But there is a lot of obscurity in both halves of this opinion.
We will learn 30 years from now or when some clerk leaks the drafts. Penultimate question. William asks, don't they need to pursue the mandamus regardless of whether Cannon gives them an excuse? She might just keep scheduling big hearings and then never decide anything. Here's the problem. You can't pursue a mandamus unless the judge has done something. Now, I know of one exception to that, which is a district judge, and this is working the back of my memory here, but when I was at Legal Times, there was a case where the DC Circuit took a mandamus because a judge had sat on it. It was a labor law case, but he had sat on it for 23 years without ruling. And I think if you're going to mandamus somebody for not doing anything, it's got to be for a really long time. Final question. Mike asks, what is the nature of the fact finding when assessing an indictment? It seems weird on a motion to dismiss. Answer, you don't do fact finding on a motion to dismiss. You assume the truth of the allegations and you interpret them in the light most favorable to the prosecution. However, what Roger was alluding to earlier was if you're trying to assess an immunity claim, there may be a case where some of these facts are official acts and subject to a different standard than others. And then you would have to ask which of them are official acts that get which level of immunity, which of them are purely personal. How do you distinguish between the two? And that may require all kinds of hearings and factual assessment. It's not really fact gathering. Is that a fair summary, Roger?
Yeah, exactly.
All right, we got through every single question and we're only 2 minutes over, and I think I get personal congratulations for that. I will be accepting notes, cards, flowers. You can send them to Lawfare headquarters. Listen, folks, we are going to wrap. I want to urge all of you to become material supporters of Lawfare, to, if not that, small donations to that link above really do make a difference. They add up. We are going to be in crunch mode for the next several weeks when this case goes to trial in New York. We're going to be debriefing really, really frequently after court sessions, and we're going to be, of course, doing Trump trials and tribulations on a weekly basis. We will be back next week from the Mask Studio, the Sconce Studio, the World Book Encyclopedia Studio. Have a great week.